Welcome to The Source, where we combine the headlines with in-depth conversations with the newsmakers themselves. I'm Pinky Webb. Today on the program, the Office of the Ombudsman moves to change the law on the Statement of Assets, Liabilities, and Net Worth, or SALN, but not without controversies. Critics also sound the alarm on the proposal to jail commenters on SALN. But the Ombudsman clarifies this is not censorship. And will the anti-graft body probe allegations of corruption on the handling of COVID-19 funds and separately investigate Pharmally? Ombudsman Samuel Martires joins us live. The Office of the Ombudsman dispels concerns on their proposal to amend the existing SALN laws. Critics slammed the Ombudsman's move, calling it a step backward in the government's move for transparency. Some groups also sound the alarm over the proposal to impose jail time on those who will criticize or comment over SALN releases. Let's go straight to the source of the story. We have Ombudsman Samuel Martires. Ombudsman, welcome back to the source. Maraming salamat po sa inyong oras.
Magandang umaga, Pinky. Magandang umaga sa iyong mga tagapanood. Kumusta kayo?
Mabuti, sir, and I trust you are well as well. Let me start with the President's Statement of Assets, Liabilities, and Net Worth, just to clarify the issue, sir, because some people are saying they are being given the run around here. Where should one request a copy of the President's Statement of Assets, Liabilities, and Net Worth?
The repository of the Statement of Assets, Liabilities, and Net Worth of the President, the Vice President, the Chair of Constitutional Commissions is with the Office of the Ombudsman. So all requests must be with the Office of the Ombudsman.
Okay, so the request should be forwarded to the Office of the Ombudsman because of, I believe, 6713, RA 6713, that states that the repository of these SALNs will be with the Office of the Ombudsman. But it seems, sir, that there is a roadblock here because of the memorandum circular that you released in 2020, limiting the access of the SALN to, I believe, 2 areas wherein it should be asked by the court, who a respondent will be under investigation, and that there must be consent from that particular official. Is that correct, sir?
Yes, Pinky.
Okay. So, sir, why did you have to, just first and foremost, order or bring out this memorandum circular number 1, 2020, limiting the access? Where is this coming from, sir? Why did you issue this memorandum order?
Pinky, this is a conglomeration of events or incidents or reports that I received from intelligence officers and from my field investigators in the Office of the Ombudsman, that the SALN was being used for extortion and harassment and for some illegal activities. I was also informed that in 2019, there were about 15,000 requests for SALN of different government officials and employees. So in I studied the SALN law, and I found out that while the law expressly states that the public has the right of access to information, the law did not provide a provision restricting the issuance of a regulation. This is what we call in law expressio unius est expressio alterius, which means simply that what is expressed is included, what is not expressed is excluded. So from that, I said, the law, while giving the right to the citizen to know the SALN of a government official, did not provide that it is or it prohibits the repository of the SALN to issue a guideline. So I made further research. I found out that in 1989, the Supreme Court issued a resolution when somebody was trying to access the SALN of a judge. The Supreme Court said, you first state the purpose of your request. That is a regulation. In 1992, in Administrative Matter number 92-9-851-SC, the Supreme Court again issued a resolution prohibiting the Ombudsman, who was the office of the Ombudsman, was requesting for the SALN of a judge. And the Supreme Court said, no, your request partakes the nature of a fishing expedition, and the request is not signed by the Ombudsman itself. So this is a policy regulation. Okay. This 1992 resolution was reiterated in 2012 by the Supreme Court again in Administrative Matter number 09-8-6-SC. The Supreme Court stated that while there is no prohibition that stands against access to official records such as the SALN, it is undoubtedly subject to regulation. With this in mind, finding support, legal support in doctrines and in jurisprudence, I told my staff, let us issue the guidelines. And the guidelines is simple. We all ask the requester to secure the authorization from the public official whose SALN is being requested. That is the reason there.
Okay, so no, basically you're saying what is included in the law is included in the law, and what is excluded in the law should be excluded in the law. And you talked about certain provisions and jurisprudence coming from the Supreme Court. So basically ang sinasabi niyo po, wala pong prohibition to access, but it's subject to regulation. Hence, Memorandum Circular number 1, na kailangan po ng consent noong official bago po ibigay ito. But let me ask you a very simple question, Ombudsman. If any official, if we need to get the consent of a particular official to be able to release his SALN, wouldn't this run counter to transparency, number 1? Number 2, even to conflict of interest. In other words, the point of really giving out their SALNs is to be able to disclose their statement, assets, liabilities, and net worth, and be able to disclose this to the public. So easily, someone like me, for example, I'm a public official, I can just not give the consent. And it becomes, somehow a conflict, it becomes clearly a conflict of interest for that particular official. Kasi ayaw ko na lang po ibibigay ko po, pero ayaw ko pong i-publicize.
I think on the issue of transparency, I don't think transparency means that pati loob ng bituka mo ilabas mo. Okay. I am not restricting transparency. I am just following doctrinal rulings of the Supreme Court. I did not say this, that the right of access to information is subject to regulations. I did not say this. This is a jurisprudence of the Supreme Court. In fact, in 2012, the Supreme Court issued its own guidance on how to access the SALN of justices and judges. Yes. In the same year, in 2019, it expanded, I guess, its guidance on how to access the SALNs of justices and judges. So hindi kami ang nagre-restrict lang eh. Even the judiciary, even the last bastion of democracy, which is the Supreme Court, is putting some restrictions because the Supreme Court said this is subject to regulations. Precisely, this is what happened in the case of Bira Ogo. Bira Ogo, on September 21, 2020, a day after we issued Memorandum Circular Number 1, wrote the Office of the Ombudsman requesting for the SALN of Vice President Leni Robredo. He alleged that he will be using the SALN of the Vice President in relation to a study that he is conducting with respect to the alleged use by the Vice President of a mansion in Quezon City, and which is purportedly paid out of taxpayers' money. I sensed that Bira Ogo was into a fishing expedition, so I denied. I did not release the SALN of the Vice President. Bira Ogo went to the Supreme Court, raising constitutionality issues. The Supreme Court denied that, saying that it does not comply with the requirements on how to raise a constitutional issue before the Supreme Court. But the Supreme Court did not stop there. The Supreme Court again reiterated its resolution in 2012 that while access to official records such as the SALN, that there is no prohibition, undoubtedly it is subject to regulation. Further, it stated, while the right of access and information to a public official's SALN is provided for under the Constitution and Republic Act 6713, the same is not an absolute vested right. Thus, the Supreme Court said, as a custodian of the SALN, such as the Office of the Ombudsman is not bound under every circumstance to allow or to grant a request for the disclosure of a SALN of a public official. The Supreme Court sustained us. The Supreme Court sustained Memorandum Circular Number 1.
There are a number of provisions that you had mentioned. You mentioned Republic Act 6713, which is a code of conduct and ethical standard for public officials and employees. Section 8 of that, Ombudsman, I know you know this by heart, basically says statements and disclosures. Public officials and employees have an obligation to accomplish and submit declarations under oath, and the public has the right to know. To which I know you just said that this is not, the Supreme Court had ruled this is not an absolute right. That's how, yun po ang pagkaintindi ko doon sa inyong sinabi ngayon lang. Meron din ho kasing Executive Order number 1, si Pangulo, on Section 5, availability of SALN, subject to the provisions contained in 3 and 4 of this order, all public officials are reminded of their obligation to file and make available for scrutiny their assets or statement of assets and liabilities. That's the second one. And of course, Article 11 of the Constitution, Section 17, a public officer or employee shall, upon assumption of office and as often thereafter as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth, etc. So basically, how I understand it, Ombudsman, is that the Constitution is basically saying that the public officials must file, must disclose to the public the copies of their SALNs, which in turn brings us back to the issue of transparency. A public office is a public trust. And yet, your memorandum order limits the access of that. So I guess the question is, sir, which holds siguro precedence? What is stated in the Constitution, as in Article 11, Section 17, also which is Republic Act 6713, which is the Code of Conduct of Ethical, Code of Conduct and Ethical Standards, and even the Executive Order of the President. Nagkakaroon ho ba kasi ng, I guess in simple terms, if one does not want to publicize his statement of assets and liabilities and net worth, that person will have the power not to do so because of your memorandum circular number 1. Because you're saying they need the consent of that particular official. In essence, pwedeng wala pong SALN na ma-disclose.
Pinky, the SALN that are under our custody are the SALNs only of the President, the Vice President,
Vice President.
the Chair of Constitutional Commissions, the Deputy Ombudsman, the local officials, elected officials, members of the military and the police from the rank of Light Colonel down,
Opo.
presidents of state universities. So hindi ho lahat ng SALN ng empleyado ng gobyerno ay nasa sa amin. Okay.
I
Each of
understand.
the repositories, I understand, have their own guidelines. So I am really wondering, why am I the only one being blamed for having a guideline on how to access the SALN of those officials whose SALNs are with the Office of the Ombudsman? The Supreme Court admitted in Biraogo that is the Supreme Court itself has its own guidelines on how to access the SALNs of justices and judges. So bakit ako lang ang sinisisi? Why are fingers pointed at me? Blaming me for violating transparency, blaming, hindi lang ako mayroong ganito eh. Even the House of Representatives has its own guidelines. You cannot just access the SALN of every congressman. So why aren't people complaining that you cannot access the SALN of a congressman?
There is this concern, Ombudsman, and maybe let me bring this out in the open. It was also it was a PCIJ report that in 2019, let's go back to even 2 years ago, that this is the first time in over 30 years that the president has not made public his SALN. So these were supposedly available from the time of President Cory Aquino to President Duterte in 2017. In essence, sir, pag upo niyo po, you were appointed as ombudsman after your retirement from the Supreme Court in 2018. That's when hindi po nagkaroon ng access ang publiko sa SALN ng Pangulo. Is that correct, sir?
That is correct. But my question again is, why are we so interested only in the SALN of the president? Why are we not interested in the SALN of the vice president? Why are we not interested in the SALN of senators and congressmen? Why are we not interested in the SALN of other constitutional officers? Why only the president? What is wrong? Are we selective? Yun naman ang tanong ko rin. Kaya, I issued this memorandum circular in preparation also with our plan to amend Republic Act 3019, which is the Anti-Graft and Corrupt Practices Act, and Republic Act 6713, which is the Code of Conduct. Preparasyon lang ho ito namin eh.
Okay. So, Ombudsman, we need to take a very short break. The source will be right back. You're watching The Source on CNN Philippines. Our guest today, Ombudsman Samuel Martires. Ombudsman, so ganito po, because there's still a lot to talk about, no? So the repositories with the Ombudsman is limited the access, saying you need the consent of the official. But Malacanang is saying you can just ask the Ombudsman. Ano ho ba talaga? Hindi nyo po i-release ang SALN ng Pangulo unless there is consent from the office of the president. So let's just clarify that, sir.
Yes, I will not release the SALN not only of the president, but of other officers whose SALN is with the office of the ombudsman without the authorization from the public official concerned. I will not.
You will not. You will not change your mind. You will not withdraw this memorandum circular number 1.
If fools they say don't change their mind, I will not also change my mind. So you can call me a fool.
So even if, as I mentioned a while ago, sir, that this is the first time that the SALN has not been released by the president, a president's SALN has not been released in over 30 years, you still won't change your mind, sir?
You know, it's really very hard. When we were issuing memorandum circular number 1, most of the employees or officers in the office of the Ombudsman were warning me, Sir, kayatang tataliwas tayo sa nakasanayan ng iba.
Opo.
Ang tanong ko naman, yung bang nakasanayan nating mali ay dapat ipagpatuloy natin? Hindi ba it is our obligasyon natin itama ang mali? So simulan muna natin dito. Maglagay muna tayo ng guidelines. Total sinasabi naman ng jurisprudence, which jurisprudence is considered as part of the law of the land. Sabi, pwede kayong mag-issue ng guidelines. Pwede niyong i-restrict. If in your mind it is smacks of a fishing expedition or illegality, then you can deny. Kaya, in Biraogo, we denied the issuance of the SALN of the Vice President. So hindi ko pwede pagpatuloy simply because it has been in a practice for the past 50 years. Kung sa pananaw ko ay dapat itigil na yon. Yun ang tinatawag nga sa isang advertisement sa TV na ang gawain na matanda kahit mali sa mata ng bata ay tama. So you have to put sanity, we have to put order to everything that we do. Not simply because nakasanayan. Hindi po pwede yung nakasanayan eh.
But if you talk about the SALNs of the Vice President, Ombudsman, there's no problem with that. Nobody has to ask your office for that, because the Vice President has released her SALNs.
I don't know if she released her SALN, but according to Biraogo, the office of the Vice President called him saying that they cannot give that authorization pursuant to Memorandum Circular number 1. I don't know how true it is. Hindi ko alam kung nagsasabi si Biraogo ng katotohanan. I have to give the office of the Vice President the benefit of the doubt. Not Biraogo. Kasi siyang interesado eh.
Okay. So I need to shift topics. Ombudsman, please clarify this. Very controversial. Did you really propose, were you serious about this proposal of jail time of not less than 5 years for those who will make commentaries on SALNs?
Pinky, I did not make any proposal for a jail term. I am just wondering why it is only now that even lawyers do not know the existence of the provisions of Section 8 of 6713 and Section 11 on penalties of the same law. Hindi ko maintindihan, ba't hindi nila alam ito? Na as early as 1989, when the law was passed or enacted, nandun na ho yun. Prohibited acts. What are prohibited acts according to the law? Those that are contrary to morals. Ba? Ano pang sinasabi na prohibited sa use ng SALN? For commercial purposes. So what did the law say? It should only be used for news or communications. Ito yung gusto namin sanang amyendahan. Naliwanagin, ano bang ibig sabihin ng news for purposes of the law? Kasi Pinky, ang labo ng batas ng 6713, it is in conflict also with the SALN provisions of 3019 of the Anti-Graft and Corrupt Practices Act. That's why we're trying to harmonize these two laws. Dahil marami hong nabibiktima sa SALN, Pinky. At ayoko during my term na pagpatuloy itong pag-victimize ng mga government officials. Magkamali ka.
Ombudsman, would you say that somehow this is personal to you based on experience?
When I was still with the Sandigan Bayan, okay, an information, a complaint was filed by the Office of the Ombudsman charging a government official for perjury. I asked the prosecutor, why perjury? Okay. Under Article 183 of the Revised Penal Code, the maximum penalty for perjury is only 2 years and 4 months. Under 6713, you can only file a case in another law if the penalty provided for in the other law is higher than the penalty provided for in 6713, which is 5 years. But the prosecutor said, we are not filing this pursuant to 6713. We are filing this perjury case pursuant to Republic Act 3019, the anti-graft and practices. Yes. So parang nangyayari, kung anong convenient sa ombudsman, doon sila. Kung convenient ng 3019, doon sila. Kung hindi, sa 6713. Why? Okay. Why is 3019? Because in 6713, there is a corrective measure provision that you cannot be charged for perjury if you read that, because the public official or employee is given the chance to correct his SALN. For example, you forgot to declare your Armalite rifle. Pag sinabi sa iyo, hindi mo naman din-declare dito, then you declare, you correct your SALN.
Okay.
Sinabi sa akin, o Martires, mayroon ka palang bahay sa Forbes Park. Ay, nakalimutan ko yan kasi regalo na pinang ko, hindi ko na mabinili yan. So I will correct my SALN, include that house and lot in Forbes Park. Sana nga totoo, ano? Pero yun yung, papunta sila ngayon sa perjury, sa 3019. Ito yung maraming nabibiktimang tao. Ito bang gusto natin? To victimize government officials and employees? Ito bang gusto natin magulong ating batas? Because remember that the reason why we're trying to reconcile these laws is because Republic Act 3019, the Anti-Graft and Corrupt Practices Act, was passed sometime in 1960. 19 years thereafter, or in 1989, Republic Act 6713 was enacted by Congress. There was no express repeal on SALN. Both laws contain provisions on SALN. Under 3019, the SALN of the President should be filed with the Office of the President. Under 6713, it should be filed with the Office of the Ombudsman. Under 3019, the filing date is January of every year. Under 6713, it is
April 30.
Oh, it is April. So, anong convenient? April, kasi yung Enero, medyo busy ka pa, di ba? So, April. Yun ang ina-adapt.
Opo.
Maraming mga bagay. Yes, Pinky.
Opo. Pasensya na po. We need to take a very short break again. Pasensya na po because we're running out of time. But we will continue this conversation after a very short break. We will be right back. You're back on The Source. At this point, we just like to thank Ombudsman Samuel Martires for joining us on television. We asked for a little bit more time as an extension so that we can discuss more topics. We will go live on our Facebook page. In the meantime, thank you for joining us here on The Source. I'm Pinky Webb. You're watching CNN Philippines.